So you're comparing this decision by the Wyoming Supreme Court to allow abortion to remain legal, to overturn the Life is a Human Right Act, to historic decisions like Dred Scott that were used to justify the enslavement of black people and the internment of the Japanese.
Yes, I think it's right in that history, and that's exactly what happened. And so they create these rights. They come up with this legal formula. They use strict scrutiny, and then they come up with a right, and they force it on all of us, and then we are not allowed to discuss it. That is totally wrong, and it's an abuse of the court's power.
Hello, and welcome back to Wyoming Watch from the Wyoming Tribune Eagle. I'm Noah Zahn, your state government reporter here. Last week, the Wyoming Supreme Court ruled that abortion will remain legal in the state, deeming 2 attempted bans unconstitutional. And if you listened to last week's episode of Wyoming Watch, we spoke with Dr. Rene Hinkle, who is an OBGYN who is a plaintiff on the case as she celebrated the ruling. This week, our crime and public safety reporter Ivy Secrest continues that reporting, and here's the other side of the story. This week, she spoke with Fred Harrison, who's the trial lawyer involved with Wyoming Right to Life and assisted in drafting the Life is a Human Right Act. That's who you heard at the start of the show. Here's that conversation with Ivy and Fred now.
On January 6th of this year, the Wyoming State Supreme Court made a ruling that effectively kept abortion legal in the state. The decision was met with a mixed response, some praising the choice and others condemning it. Last week, we spoke with plaintiff and OBGYN Dr. Rene Hinkle about the response to the decision from the abortion rights advocates. This week, we welcome Fred Harrison, an attorney who represents Wyoming Right to Life and an author of the bill that was challenged in this case, the Life is a Human Right Act. Welcome, Fred.
Hi, Ivy. Nice to be here.
So, at this point, I believe the public is well aware of last Tuesday's decision from the Supreme Court, but they might not be aware of the details behind that decision, the legal justifications behind that decision. As an attorney who was involved in this case, walk me through what legal justification was given and then what legal justifications or legal standards were not evaluated in this case.
Well, I think that's very important, how you have to know the history of the case. And in order to know the history of the case, you have to go back to Roe versus Wade, of course, in 1973. And in that case, the Supreme Court came up with a thing called substantive due process. And in the process of creating that new right that didn't exist, the right to abortion, they essentially shut down all political discussion. There wasn't any political discussion after that of abortion, because abortion was the law of the land. And you didn't have any choice in the matter. You didn't have any way to lessen the restrictions because it was substantive due process. We went through almost 50 years of that from Roe versus Wade, in which, of course, several of the Supreme Court justices repeatedly said that it had shut down all political discourse, so the nation could not really reach a consensus, or individual states could reach a consensus on abortion. And so because of that, we had eventually the Dobbs decision. And in the Dobbs decision, Justice Alito wrote a 98-page opinion, and that said that substantive due process was a bad idea, which it was a bad idea because you have procedural due process and you have substantive due process. Substantive due process has been used to introduce all kinds of bad rights, such as the right to property ownership in the South right before the Civil War. Dred Scott was a substantive due process decision. And so there's been a lot of criticism of substantive due process, and Dobbs said substantive due process should be at an end so that the states could decide the issue themselves. The Wyoming Supreme Court comes along, and they go right back to substantive due process. And they use a process called strict scrutiny, which is the highest standard possible. It's the highest standard possible, and what it means is that there has to be a compelling state interest, and it has to be the least restrictive way of handling abortion, which means that the state can never win. And so once you've made that decision that abortion is a fundamental right, you've shut down all political discussion. And so that's where we are right now. We have no political discussion or the ability to discuss that without another constitutional amendment, which would actually, as my mind, the constitutional amendment would only reopen the discussion, which is now prevented by the Supreme Court opinion. So we can't reach a consensus. As in my mind, the Constitution should be neutral on abortion. Now it is pro-abortion, the way the Supreme Court has done that. Now, I also want to talk a little bit about what the Supreme Court did, the Wyoming Supreme Court, Justice Garden's opinion, and that is they used strict scrutiny. Strict scrutiny is not supposed to be used as a legal standard if the Constitution itself states what the standard is. In this case, the Constitution specifically states what the standard is. It says in Article 1, Section 38, the legislature may determine reasonable and necessary restrictions on the rights granted under this section to protect the health and general welfare of the people, or to accomplish the other purposes set forth in the Wyoming Constitution. It sets forth specifically that the legislature has the authority, not the courts, the legislature has the authority to determine reasonable and necessary restrictions, which is what they did. Now, you may think, I think the majority of citizens in Wyoming, from the polling, think there should be some restriction on abortion. That's over 62% that believe there ought to be some restriction on abortion. Given the court's ruling, we can have no restrictions on abortion because any restriction on abortion, being a fundamental right, is wrong, according to the Supreme Court. So that's the problem we have, because we can't even begin the discussion, and we can't heal the divides or even really have a political discussion about abortion until we have a new constitutional amendment.
So that article that you just read, Article 1, Section 38, which was used throughout the opinion by multiple justices to evaluate this act, it also starts out with Wyomingites have the right to make their own medical decisions.
Right.
Before it has that caveat of the legislature has the right to restrict within reason.
Right.
Wyomingites do have the right to make their own medical decisions. So for advocates of this decision from the Supreme Court, that's really been the pinpoint that abortion's a medical decision. Wyomingites have the right to that. What is the concern then of allowing that abortion to be seen as a fundamental right if it is a medical decision? If we're treating it like a medical decision, what bearing does that second half of the amendment have?
All right, let's back up. Okay, where it says each competent adult shall have the right to make his or her own health care decisions, that was a procedural provision of the Constitution. That's very important because people get confused over procedural due process and substantive due process. Procedural due process is I have a right to a fair trial. I have a right to select my own health insurance in that process. And that's what it was originally written for. It was a procedural process. The Supreme Court has turned it into a substantive due process. So what this is like, it's like the amendment was meant to say, you get to choose whether you go into a restaurant and order from the menu, okay? Ordering from the menu, you don't get to choose what's on the menu once you go in that restaurant. The people that own the restaurant make the decision. That's the same position as the legislature right now. The legislature makes the decision as to what is health care. That's the way the structure of the amendment is. They decide what is health care. They decide what's on the menu. You decide what you want off that menu. That was the whole premise of the amendment as it was passed. The Supreme Court, by writing that in there, did a very dangerous thing. What they did is they said, we can write any right we want to write into the Constitution if it's a health care decision. Now that could mean the legislature cannot restrict transgender surgeries on minors, because it says also in here that natural persons that are in charge of children, the parents, may decide to have transgender surgery. They may decide to have their breasts of their daughter amputated off. And the legislature should have the authority to say that's not correct. You can't do that. But if it's a health care decision, according to the Supreme Court, you can't make that decision anymore. That decision is a fundamental right, And what other fundamental rights are there in here? Assisted suicide, the right to use medical marijuana, the right to use heroin, the right to use morphine. What other health care rights are there to use? The list is ad infinitum. The way the Constitution is meant to be is that if it doesn't say, for instance, that you have a health care choice such as abortion, then you don't have that. That's not in there. It's only in there if the legislature puts it in there. It's only in there if because it excludes. Otherwise, you can have all kinds of rights that are going to come into existence. We don't know the full list of ramifications. But what the court has done is very dangerous because they can create any kind of right, and the legislature doesn't have the authority or the ability to discuss it.
So when we're looking at that, then, this dangerous decision that you say means that we can kind of play around with any sort of medical decision as a right, regardless of the state laws.
Right.
I'm curious, abortion, prior to this act being passed, abortion was legal in the state of Wyoming. Whereas something like medical marijuana wasn't. Wyomingites have, up to this point, decided that they are uninterested in having marijuana accessible to Wyomingites.
Right.
Is your concern then that other not pre-existing items on the menu, so to speak, would become items on the menu because of this reasoning?
Absolutely. They have to. They have to. I don't think we have a choice. The way this is structured. You said that it's only been legal when it was forced upon us by the Supreme Court of the United States in Roe versus Wade. The entire history of the state of Wyoming since territorial times, and I've traced this through, there has never been a time in Wyoming when we were left to our own devices and the legislature was able to pass laws that we did not have strict laws against abortion. Now, you have to, in the beginning of the 20th century, doctors were very much opposed to abortion because they believed they had two patients. The OBGYNs of the turn of the century, well, before they even had OBGYNs, they believed and they led the charge to outlaw abortion across the country. That's where our laws came from, is from that push by physicians that believed that abortion was wrong. If you go back to the history of this country, 2,500 years to the Hippocratic Oath, Hippocrates, what did he say? He said the first rule is do no harm. Second rule is procure no abortion. That was the Hippocratic Oath. And that oath existed until a bunch of lawyers, 5 lawyers, decided it didn't exist in Roe versus Wade. That's one of the things they did, is they declared that abortion was health care for the first time in the history of the country. That was in 1973. So to say that abortion was legal is not true in Wyoming when we were left to our own devices. As soon as Roe versus Wade was done away with by Dobbs, the Wyoming Supreme Court outlawed abortion. And then it was intervened upon by plaintiffs such as Rene Hinkle. So that's how we got there.
Okay. Gotcha. So,
and this is kind of important because Scalia, in his writings, says that it's very important that we know the history of things like tradition before we create new rights, and that rights are not created by the courts. In this case, this right has always been created by courts, by judicial edict.
So when we're talking about the history of the right, we're talking about the state not having legal abortion prior to Roe v. Wade, then having legal access to abortion because of Roe v. Wade, a decision made at the federal level as opposed to the local.
Yes.
And then we're talking about a return to the state law after Roe v. Wade was overturned.
Yes.
That's what you're talking about when you say that it was not legal prior. You're talking to prior to Roe v. Wade.
Right.
Okay. So, when you talk to advocates of abortion, they kind of have the opposite argument to what you just discussed, with abortion not being the law of the land, doctors leading the way to not have it. There have also been doctors, OBGYNs, who have pushed for the right pre-Roe v. Wade. It has kind of been a split issue down the line for quite a long time. I'm curious, with this decision that was made, and the impact on local Wyomingites, what does this decision mean then for the continuance of that conversation, that continuance of that split between the OBGYNs who feel like abortion is healthcare and the OBGYNs who feel like abortion should not be accessible in the state?
Well, I'm kind of glad you brought that up, because I think that one of the things about this decision that was decided by the Wyoming Supreme Court is a very one-sided argument that took place. The state of Wyoming, the Attorney General, for whatever reason, decided not to present evidence at the trial court level. We tried, the amicus people, pro-life people, Thomas Schott had a brief that he submitted with multiple OBGYNs that were against abortion in Wyoming OBGYNs. Those people were never heard. Their affidavits were never considered. They were never part of the discussion. And so there are lots of OBGYNs. 90% of the OBGYNs in the United States do not perform abortions. Only a very few perform abortions. So it's not necessary to an OBGYN's practice to have access to abortion. That is an incorrect assessment, and there are certain OBGYNs, two of whom were in this case and were presented, and their affidavits are the only affidavits that were presented to the Wyoming Supreme Court. So, one of the things that bothers me about the court is it loaded the deck. It loaded the dice in favor of abortion when it did this in the very beginning by prohibiting any amicus briefs and by not considering any other evidence outside the record. And because the Attorney General did not present any evidence, they did not have any ability to really assess what is important and critical to the decision, what is reasonable and necessary. The legislature had that information. The legislature made findings in the Human Rights Act, and the legislature's findings were never refuted by anybody because the court only heard one side. And so they only heard one side, and so there was never any argument that really took place. There was a very closed-minded court. I want to be very clear about that.
So when you say that the amicus briefs of the state were not heard...
Not the state.
Or sorry.
Right to Life and the OBGYNs. They both submitted, OBGYNs that were against abortion submitted an amicus brief by Thomas Schott. Those briefs were never considered by the court because they have a policy they don't like to have amicus briefs, I guess. But they only considered one side, and the state of Wyoming never presented any evidence. They said it was a facial argument, which the court rejected.
So when we're saying that side of things was not heard, does that include the hearing in April where both sides, open to the public, viewed by many, were able to come in and discuss the two sides to this case? Does that include that moment, or?
That moment doesn't count because by then there's no evidence in the record, and the court says there's no evidence in the record. Well, why isn't there any evidence in the record? The state didn't present any evidence, and the court chose not to consider any amicus briefs. So all the other side, it was very one-sided, and the problem is now they effectively closed the door to further discussion because they say abortion, no matter what, is legal in all circumstances. Now, you have to think how radical this decision is, because it's horribly radical, because it says that abortion in Wyoming law is now legal to the moment of birth. There is no restriction on abortion whatsoever. It's a fundamental right, and you can have partial birth abortion. I don't think the majority of people in Wyoming want partial birth abortion, but this decision throws that door wide open. The only thing that may restrict it is the federal law against partial birth abortion. That may restrict it if the feds just actually decide to enforce the law.
If that's where we're at a point where this decision opens this door to all of these potential types of abortion. What does that mean? I mean, you're not the first person to come forward and be frustrated with this decision. You're not the first person to send us to the paper opinions about how this decision leaves behind certain groups in Wyoming, how this decision neglects certain aspects of the amendment, which has been brought up in a couple op-eds sent our way. I'm curious if we're at this point where everything is kind of open, what does that mean? What do you see that meaning going forward?
I think that fundamentally, my problem is that the court has assaulted the democratic process. When they chose to use, so my point is, and lots of legal writers have written on this subject besides myself, when you have the standard set forth in the Constitution itself, which is in this case the legislature may determine reasonable and necessary restrictions on abortion, on health care rights, when you have that in there, you don't go to strict scrutiny. Strict scrutiny is a concept of the courts that was created by the courts. It goes back to the Dred Scott decision as one creating a right to property in that case, which were black people at that time. It was then used, the next time it raises its head is Korematsu, which is the decision that the United States used to intern Japanese people. It has a very bad history, strict scrutiny. The court adopted strict scrutiny. Roe versus Wade was a strict scrutiny case. They adopted this stringent standard, which means that the state will lose no matter what, and they used that stringent standard, and they applied it to abortion in this case, ignoring the Constitution. That's very troubling. And the reason it's very troubling is it means that the court completely ignored the Constitution that it's sworn to uphold. And that's very troubling.
So you're comparing this decision by the Wyoming Supreme Court to allow abortion to remain legal, to overturn the Life is a Human Right Act, to historic decisions like Dred Scott that were used to justify the enslavement of black people and the internment of the Japanese.
Yes. I think it's right in that history, and that's exactly what happened. And so they create these rights. They come up with this legal formula. They use strict scrutiny, and then they come up with a right, and they force it on all of us, and then we are not allowed to discuss it. That is totally wrong, and it's an abuse of the court's power.
There's a huge moral discussion around abortion, around whether or not people should have access to it, whether or not it's right or wrong. It goes hand in hand with the conversation about when life begins. There's religious differences, there's moral differences, and when life begins, all those things, even some medical disagreements up to this point. What are your moral concerns with having abortion accessible in Wyoming?
You know, I have very strong moral convictions about abortion. I think it's totally wrong, but that's not the debate. Okay, I don't think that's the debate. If I say to you that I have very strong abortion beliefs and that it is the killing of an innocent human life, which I believe, and that I want to force that on you in this discussion, I think we have to have a discussion about that, because I have to assess your moral beliefs. And I think that morality, and one of the things that was very troubling to me about Dr. Hinkle's discussion about morality, so far as I could tell, there is no morality from her point of view. It's just whatever everybody's opinion is. The legislature discusses morality. That's its job. It just, every time they pass a law, whether it's murder or you can't steal, it's a moral decision. That's a moral decision. That is the role of the legislature. When the court steps into that realm, it delegitimizes itself. It makes itself a rogue court when it steps into the morality decision and comes down on one side, that abortion is always right. That's the side they came down on. They came down on the side that abortion is always legal, that there can be no restrictions on it. That's the side they came down on. That is a moral decision that they made that is repugnant to the majority of people in the state of Wyoming. I think you may say, okay, the legislature went too far in the Human Rights Act, okay? They said abortion is never legal except in certain exceptions. Maybe you disagree with that. Then you can have that discussion with your legislator, and you can come up with something in the middle. You can look at the European model. In Europe, there are no constitutional amendments saying that abortion is a right, except maybe in France. In Germany, that doesn't exist. They've had discussions, and they come up with 6 weeks, 8 weeks, 12 weeks, whatever it is in the European countries. They come up with middle ground. We can't come up with middle ground because the court says we can't. It says it's a fundamental right, so I can't ever in any way impinge on that fundamental right. So there can be no discussion. That's the point. And they've politicized themselves by doing this. They've delegitimized themselves as an institution separate and apart. And that's where the legislature's upset, and I can see why.
So for our listeners who may not have listened to last week's episode, you're referring to when Dr. Hinkle inferred that morals should not be legislated, and you were saying that every legislative decision is a moral decision.
That's her position on that makes no sense whatsoever, because legislatures always pass morality. That's what their job is.
So flowing through with, if we agree that the legislature's job is to enforce morality, what does this decision mean for the legislature's ability to do that?
Well, I don't know that the job is to enforce morality. I don't think I would say that. What I would say is they have the right to say what the limits are. In other words, what are the limits? Are we going to have transgender surgeries? Are we going to have abortion after the 6th week? Are we going to have abortion limited to the heartbeat? Those decisions are legislative decisions as to what kind of society we're going to have and what the limits are. So the legislature stays in its lane, and the Supreme Court should stay in its lane.
If we're looking at how we get to a point where each stays in their lane, there's been quite a lot of discussion around this in the public sphere recently. There's been suggestion that we should change how we appoint judges. There's been discussion of writing and passing some sort of constitutional amendment in the upcoming legislative session. There's been discussion of essentially putting abortion up to a vote to Wyomingites. If we're going to represent Wyomingites, just put it up to a vote and we'll see what everyone here decides. Do you think that solves the issue of having the court stay in their lane, the legislature stay in theirs?
I think we have a real problem in Wyoming in that the court has chosen to totally ignore the Constitution. When they ignored Article 1, Section 38, subsection C of that amendment, when they totally ignored it, said the legislature exercising its authority to make reasonable and necessary restrictions on abortion, when they ignored that, they opened the door to questioning whether we need in this state. And in my mind, when you talk about constitutional amendments, one of the things we need an amendment that says the ordinary original meaning of the Constitution is what we follow. And I think we need that kind of amendment. And I think we need an enforcement provision that if the court steps outside its lane, then something has to happen. And I have proposed that to some legislators, because I think that's one of the ways we start. Because this isn't just about abortion. It's about how we run this state. And they have disenfranchised, because when the Supreme Court said, we're going to ignore Article 1, Section 38C, when they said that, they are ignoring the vote of the voters. The voters passed that amendment. Not the legislature. The voters passed that amendment. And the voters gave the legislature the authority to restrict abortion, or to restrict health care. When they gave that authority to them, the Supreme Court disenfranchised every voter in Wyoming by their decision.
So that amendment that we've been discussing, Article 1, Section 38, that was passed in 2012. The original intent was it's specifically in response to the Affordable Care Act, also known as Obamacare. So what I'm hearing you say is that you believe that we should have some sort of amendment that requires that we look at these constitutional amendments in the initial intent through the
Right.
lens of the intent of the
Right.
legislature, which is currently not a requirement. You're looking at the language, not necessarily the intent.
Mm-hmm.
And then if I'm applying that logic, and correct me if I am wrong here, but if I'm applying that logic, then you wouldn't have applied this amendment to this issue because it wasn't intended to address abortion.
And that's what Justice Gray said in her dissenting opinion too. I don't think it does apply in this case, but if you do apply it, you have to apply all of it. You have to apply the part that says the legislature can make necessary restrictions. And they didn't do that. They ignored that part. And when they did that, they stepped outside their lane. Now, I want to talk to you a little bit about selection of judges, because I think this is very important. We have the Missouri plan in Wyoming, which supposedly is the merit plan, right? And so we are supposedly selecting people based upon their merit. The problem with that is that lawyers are taught in law school that we all emulate and try and be Harry Blackmun, the guy that wrote Roe versus Wade, because those are the judges that make important decisions that change the entire landscape of the law. And so we're all taught to be that kind of lawyer. Now, the problem with that is that means that you're not following the original intent of the Constitution. You're not following the original meaning of the Constitution. You're creating law. That's a problem. I think we need to have a selection system where people take an oath not just to support the Constitution, but to support the original meaning of the Constitution as it was drafted. Then we wouldn't have this problem, because Article 1, Section 38 clearly has nothing to do with abortion. Never did. It wasn't meant to. They applied it because of the breadth of the language. But, in doing so, they didn't even follow it. They didn't follow. They picked the part they wanted to select as the part they would follow. What needs to come out of this legislative session is a restoration of our rights, our right to discuss the issues and have a meaningful debate that will result in laws that are passed by the legislature. So I think right now the law in Wyoming, given the Supreme Court decision in State versus Johnson, is that abortion is a fundamental right and you can make no restrictions upon it, and you, legislature, keep your hands off. I think that out of this discussion, we need to have a restoration of rights that say that the citizens are in charge, and that when they passed their constitutional amendment in Article 1, Section 38, it meant something. And when it meant something, it meant all of that something. And it meant that the legislature is empowered to impose reasonable and necessary restrictions on the rights set forth in that article. And that has been taken away from us. And that's a disenfranchisement of the voters. And that's wrong, and we need to do something about it.
Well, thank you, Fred, for coming on. I really appreciate it.
Thank you.
Now, here's Taylor Staples, our arts and entertainment reporter, to bring you a roundup of some upcoming events in the area this week.
Today, January 16th, from 5 to 9 p.m., there's the annual Chili Challenge fundraiser put on by the Boys and Girls Club of Southeast Wyoming, taking place at the Event Center at Archer. Then, today is also day one of a 2-day conference called Building Firm Foundations for a Lifelong Love, which will be held at Central High School from 6 to 9 p.m. tonight, tomorrow from 9 a.m. to noon. Also tonight at 7:30 p.m., there's the Dude Dad Parents Night Out comedy show for those 18 and older at the Cheyenne Civic Center, as well as a Braxton Keith and Randall King country music concert at the Lincoln Cheyenne at 8 p.m. Tomorrow, Saturday, January 17th, there's the Winters Farmers Market from 9 a.m. to 1 p.m. at the Cheyenne Depot, a Cheyenne Audubon birdwatching field trip to Raptor Alley from 9 a.m. to 4 p.m., meeting at Lions Park, a Birthday Bash Zentangle crafting event from 10:30 a.m. to 12:30 p.m. at the Cheyenne Botanic Gardens, and a Good Dirt class at the library from 2 to 4 p.m. that teaches people about drainage and soil. There's also a paint and sip class from 5 to 7 p.m. at the Cats and Coffee Connections Cafe. On Sunday, January 18th, there's a free teen hoop shoot competition at the Beast Gym on Sunflower Road at 9 a.m., hosted by the Cheyenne Elks Lodge, as well as a Wyoming Sportsman gun show at the M&K building at Archer from 9 a.m. to 5 p.m. There's also a bridal expo at Little America from noon to 4 p.m. And later, there's a pottery painting class at Cats and Coffee Connections from 1 to 3 p.m. On Monday, January 19th, the Sportsman Gun Show is taking place again from 9 a.m. to 5 p.m. at the M&K building at Archer. And on Tuesday, January 20th, there's a Senior Planet session at the library from 10 to 11:15 a.m. where adults will learn about digital skills regarding finding information on elected officials. There's also a Cheyenne Audubon program teaching people how to use the herbicide Rejuvra at 6 p.m. and a meditation session from 6:30 to 7:30 p.m. Both of those are also at the library. On Wednesday, January 21st, there's a Library for All session from 12:30 to 2:30 p.m., an adults-only K-pop movie sing-along from 5:30 to 7:15 p.m., and an English-Spanish story time from 6 to 7 p.m. All of those events are also at the library. Finally, on Thursday, January 22nd, there's a Libby Learning session from 10 a.m. to 11:15 a.m., a Teen Writing Club session from 4 to 5 p.m., and a new lecture series at the Cheyenne Frontier Days Old West Museum titled Discover and Discuss, a historical look at early railroads from 5:30 to 7 p.m. For more events, go to wyomingnews.com/calendar.
And finally, before we close out today, here's a quick recap of some of our top stories and headlines from the past week. First up, the Joint Appropriations Committee wraps up its final week of meetings this week before the session begins next month. It made big moves, including cutting funding for the Wyoming Business Council and slashing funds for Wyoming Public Radio. It also approved axing $61 million in funds for the University of Wyoming and denying tens of millions of dollars in requested funds from the Wyoming Department of Health. Movement in the federal races continued as Wyoming Superintendent of Public Instruction Megan Degenfelder announced her intention to run for governor, and former State Superintendent Jillian Ballow said she will run for the U.S. House seat, which is up for election this year. The Wyoming Professional Teaching Standards Board dismissed a complaint Monday against a Carpenter Elementary School teacher accused of neglecting an 11-year-old boy, which his family says led to him taking his own life at school in 2023. After nearly 4 hours of police presence Friday afternoon at the Bighorn Motel, police took a suspected shooter into custody. 69-year-old Cheyenne Harold Wayne Sarvis was booked into the Laramie County Jail for attempted first-degree murder and several other charges. And finally, members of the Cheyenne City Council took almost 2 hours of heat during their regular meeting Monday night over a proposed ordinance that would let certain city officials apply for administrative inspection warrants. During the public comment period, 21 members of the community came forward to express their heavy opposition either to the ordinance as written or the idea of the warrants as a whole. That's all for this week's episode of Wyoming Watch. Thank you so much for tuning in, and be sure to check back next Friday for more.